Hello, everyone. Thank you for joining our program today. My name is Eric Eisenman, and I am a partner in Husch Blackwell's Milwaukee office. I currently serve as chair of our National Labor and Employment Practice Group, and along with my colleague Katerina, who I'll introduce in just a moment, serve as co-chair of our Workplace Diversity, Equity, and Inclusion subpractice. I am really looking forward to our discussion today, but I have just a few housekeeping items to start with. At the bottom of the audience console, there's a couple different application icons that you can use during the presentation today. If you have any questions during the webcast, you can submit those via the question box. We'll be trying to monitor those during the presentation today. So if you do have substantive questions that you'd like us to address, please feel free to put them in there and we'll try to get to them if we have time. All the materials for this presentation are going to be available in the program materials folder, which is one of those icons. The program has been approved for continuing legal education hours. To report your hours, you can click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a copy of a recording of the website that you can share. Towards the end of the program, we'll be sure we would ask that you complete our short survey. We use that information and the feedback that you provide to make sure that we're delivering timely and interesting content to you. So we really appreciate that. That's it for housekeeping. It's now my pleasure to introduce my co-presenters today, Amanda Garcia-Williams and Katerina Colon. Amanda is Husch Blackwell's Chief Diversity, Equity, and Inclusion Officer. In that role, she supports the development of an inclusive culture here at HB so that attorneys and staff are best equipped to meet client needs. We're extremely lucky to have Amanda as a leader in our firm, and there are lots of things that I like about her, but one in particular is that she is an experienced labor and employment lawyer. She began her legal career in the L&E space, helping clients create more inclusive environments. She soon joined Michigan State University's Office for Inclusion and Intercultural Initiatives, where she led Title IX investigations and delivered educational programs across the campus on inclusion, anti-harassment, and implicit bias. Amanda later took a role with Jackson National Life Insurance, serving as general counsel in the general counsel's office, while simultaneously building the company's first diversity and inclusion working group and developing an initial diversity and inclusion strategy. Katerina is a labor and employment attorney here in our Milwaukee office. And as I mentioned before, one of the co-founders and co-chairs of our Workplace Diversity, Equity, and Inclusion subpractice. She has experience in a wide variety of labor and employment matters, from litigation to investigations to support in complex corporate transactions. She holds a number of leadership roles, both inside and outside the firm, and is a frequent author and speaker on many labor and employment topics, including the intersection between labor and employment law and DE&I, which is precisely what we're planning to talk about today. With that, I am going to turn it over to Katerina to get our conversation started.
Thanks so much, Eric. I appreciate it. And good afternoon, everyone. Thanks so much for joining us. We're thrilled that you are here. As Eric mentioned, we're going to be discussing some DEI topics today, and more specifically, we're going to be reviewing some of the pushback we've seen since the Harvard for Fair Admissions decision by the Supreme Court. Then we're going to transition into some Q&A and to shed some light on the practicalities and recommendations for employers in light of this pushback. Because this is a follow-up to a more in-depth discussion of the affirmative action decision that we had previously, I'm going to provide just a very quick overview of the case, although I'm sure many of you are familiar with it by now. On June 26th of this year, the Supreme Court held that universities may not use race by itself as a plus factor in college admissions. The majority effectively overruled its 2003 decision in Grutter v. Bollinger, in which the court upheld the university's consideration of race as one factor among many in an effort to assemble a student body that is diverse in ways that are broader than just race. In justifying this most recent decision, the court opined that the use of race in admissions is unconstitutional because the goals of such programs, such as diversifying the student body, are in the court's view too amorphous and unmeasurable to determine whether they are necessary to achieve a compelling interest. Notably, however, the court did not foreclose all race-related considerations in college admissions, explicitly stating that the opinion should not be construed as prohibiting universities from considering an applicant's discussion of how race affected their life, be it through discrimination, inspiration, or otherwise. And perhaps even more important for purposes of our discussion today, the decision does not itself specifically govern DEI programs outside of the college admissions process. But that's not to say that there has not been an impact on employers' DEI programs since. Shortly after the decision came out, state attorney generals in 13 states sent a letter to Fortune 100 companies explaining their interpretation of the decision and its application to private employers. The AG letter asserts that odious discrimination is of the distant past and threatens imminent serious legal consequences for companies that engage in a laundry list of activities that these attorney general have deemed violative of the constitutional framework set forth in SFFA. The AG letter explicitly calls into question DEI programs operated by private employers. It's important to note that these letters do not have the force of law and do not impose any legal obligations on employers. In addition to the AG letter, several individual legislators have sent similar letters to private employers. For example, on July 17th of this year, Senator Tom Cotton of Arkansas sent a letter to 51 law firms citing civil rights laws that he believes these firms and their clients may be violating by maintaining these DEI programs. Senator Cotton's letter advises law firms to preserve documentation related to those DEI programs in preparation for private lawsuits over alleged unlawful racial discrimination by way of these DEI policies and practices. The letter also asserts that law firms have a duty to advise their clients of the risks associated with making employment decisions based on race, and warns that federal law has long prohibited treating employees differently because of their race. It's worth noting that unlike the impact of the Supreme Court's decision on college admissions, again, the AG letter and these letters from state senators do not carry the force of law. Here we go. Interestingly, the EEOC issued a press release just hours after the decision with a statement from Chairperson Burrows in response to the decision. Burrows was appointed to the commission by former President Barack Obama and designated the chair by President Biden. Chairperson Burrows stated that the court's decision does not address employer efforts to foster diverse and inclusive workforces, and opined that it remains lawful for employers to implement diversity, equity, and inclusion and accessibility programs that seek to ensure workers of all backgrounds are afforded equal opportunity in the workplace. Another commissioner, Andrea Lucas, who was appointed by former President Donald Trump, also expressed views on workplace DEI programs in commentary that was published on June 29. And during a subsequent media appearance. And her commentary noted that the Supreme Court's ruling does not alter current federal employment law, and that Title VII has always prohibited race as a factor in employment decisions. But Commissioner Lucas also stated that the Supreme Court's ruling should prompt employers to take a hard look at their corporate diversity programs. So, for example, she opined that explicitly or implicitly taking race into decision-making for employment decisions through initiatives such as race-restricted internships, race-restricted mentoring, and race-focused promotion decisions may already be violating the law. So
it's
what
worth
exactly—
noting, Katerina, sorry to just interrupt, I feel like our audience is probably looking at that, which is that these two commissioners within the EEOC itself effectively are taking opposite positions on this. So this is part of the reason why we thought it would be helpful to have this conversation. You mentioned this. The EEOC is a federal agency charged with enforcing the employment laws, but there is historical precedent for certain positions of the EEOC being challenged in federal court. So it is the federal courts and ultimately the Supreme Court that will rule on this. But just worth acknowledging and I think empathizing a little bit with our clients and attendees how sort of confusing this sometimes can be.
Yeah, definitely. And I think what I think is interesting is that Commissioner Lucas made the point that these considerations have always been unlawful under Title VII. And we would say that our advice is never to make any employment-based decision solely on race. And so while they do appear to be conflicting in that one is more cautionary and one is saying we don't think this has any direct impact on employers, I think the outcome is very much going to be the same in terms of how we move forward in implementing our DEI programs. So regardless of the AG letter and Senator Cotton's letter, the ruling itself does not have any immediate impacts on private employers. Race-based decision-making in the workplace, again, has always been unlawful and will continue to be unlawful. Employers should know that well-structured DEI programs do not run afoul of any federal, state, or local discrimination laws. However, the Supreme Court has now opened the door to and made more likely future legal challenges against private employers' DEI efforts. So the pushback we have seen have primarily fallen into two categories, the first of which is shareholder derivative actions. And these are lawsuits brought by a shareholder or group of shareholders on behalf of the corporation against the corporation's directors or officers. And we will have an example of this for you. The other pushback we have seen involves lawsuits brought by individuals who are seeking to overthrow or restrict company DEI initiatives on the basis that the companies are engaging in reverse discrimination. Shareholder derivative lawsuits tend to center around shareholder demands and are often funded by conservatively backed organizations seeking to abrogate DEI efforts with proposals for impact audits and demands for DEI policy retractions. For example, in March of last year, the American Civil Rights Project published an open demand to Starbucks board on behalf of the National Center for Public Policy Research, demanding that Starbucks retract its DEI initiatives. Starbucks implements various initiatives involving DEI and hires independent consultants to advise on how the company can better advance DEI for its employees, customers, and communities, which I'm sure a lot of your organizations do as well. When Starbucks rejected shareholder demands to vote against every Starbucks director up for re-election and to require Starbucks board nominees to disclose their ideological perspectives, they created a board committee to review Starbucks' woke business practices. And so Starbucks rejected this, and then the group filed suit. A federal district court in Washington recently dismissed the action, holding that the plaintiffs did not fairly and adequately represent the interests of Starbucks and its shareholders in launching the challenge, and had not pled particularized facts showing that Starbucks board of directors had wrongfully refused the plaintiffs' demand to dismantle the company's DEI initiatives. So that decision really illustrates a procedurally sound way for corporations to respond to shareholder demands challenging ESG-related initiatives and any other business decisions. Engage counsel, consult with relevant subject matter experts to assist you in evaluating these challenge practices to ensure that they are in the company's best interests and are done in a way that is lawful. We believe, however, that the greater threat to employer DEI programs come from claims by employees that are alleging reverse discrimination. So reverse discrimination occurs when members of a historically advantaged group are discriminated against based on a protected characteristic. Both the EEOC and federal courts have recognized reverse discrimination claims as potentially viable causes of action on the ground that the 14th Amendment and Title VII of the Civil Rights Act apply equally to all races and genders. And now we actually have a poll question for our audience. Has your company ever had a claim of reverse discrimination filed against it by a former employee? We will give you just a few seconds here to submit your answers.
And we'll confirm that this is completely anonymized. We are not collecting this information for any purpose to market our services or any other reason. We would encourage you to be transparent. It's going to be anonymous in the process. We thought it would be helpful for a group here to just see some benchmarking.
Thank you for that disclaimer. All right, just a few more seconds to submit your responses. Okay, so we have about 19% yes, about 50% no, and about 31% unsure. And so, if I recall correctly, we had asked this same question during a presentation maybe a year or two ago. And my recollection is that the number of yeses was lower than it currently is now. So this is consistent with our understanding that we are seeing more of these claims after the decision out of the Supreme Court. So as I mentioned, we've seen a trend in an increase in the reverse discrimination claims, some of which even came prior to the Supreme Court's decision. For example, in Phillips versus Starbucks, a New Jersey federal court awarded $25.6 million to Phillips, a white manager who was fired following an incident with a Black customer. So Phillips, who is white, lost her job as a regional director a few weeks after a widely publicized incident in April of 2018, when police were called to remove 2 Black men from a Starbucks in Center City, Philadelphia. In her lawsuit, she alleges that Starbucks punished white employees who were not involved in the arrest in an effort to convince the community that it had properly responded to the incident. And notably, Phillips had been terminated while the manager of the location, who was Black, kept his job. And the jury ultimately found that the plaintiff's termination was motivated by her race. In another case, Duvall versus Novant Health Incorporated, a jury in the United States District Court for the Western District of North Carolina awarded $10 million in 2021 to a white former executive of Novant Health who claimed that he had been terminated in part due to the company's desire to meet DEI targets. Novant's DE&I efforts ramped up in August of 2015 after the company signed a national hospital system initiative with the American Hospital Association to address healthcare inequities. And after the murder of George Floyd, the AHA issued a statement condemning racism, bigotry, discrimination, and violence of any kind, and reiterated its commitment to addressing healthcare disparities. Duvall was ultimately terminated for what he claimed was a result of these diversity efforts, despite performing at a high level. The court's written order on the post-trial motions was notable, and that the judge stated there was also evidence that Duvall was terminated under circumstances that reasonable jurors could conclude resulted because of his race and gender, namely the DE&I initiative with an expressed timeline to remake the workforce and reflect the community and embed a culture of D&I at the company. So these are really good reminders that D&I efforts should be inclusive and not exclusive. And that is incredibly important to craft these initiatives with the assistance of human resources and your legal teams. We have a few more case examples here. So Myersberg versus Morgan Stanley. Kevin Myersberg, who was head of Morgan Stanley's executive services group targeting corporate executives with large stock holdings, accused the firm of terminating him and replacing him with a Black woman manager to meet diversity targets set by the company. His complaint alleged that his replacement, who was a managing director on the firm's financial wellness team, had 10 years of experience in contrast to his 26, and was focused on providing financial education to mass affluent customers with less than $250,000, in contrast to the $750,000 plus prospects his former unit targeted. When he asked his superiors what he could have done differently to retain his role, the head of Morgan Stanley's at-work division allegedly told him that the decision was not based on his performance and expressed concern that his replacement did not have an understanding of the executive service team's business model. And lastly, we have Bradley versus Gannett Company, in which 5 former employees filed a proposed class action lawsuit accusing Gannett of reverse race discrimination. And the suit claims that white workers were unfairly terminated or passed over for opportunities and replaced with less qualified women and minority candidates in the interest of meeting the company's goal of having a workforce that better reflects the demographics of their community. Despite this apparent rise in reverse discrimination cases, employers should know that these claims are not easy to prevail on, at least historically. Plaintiffs alleging reverse discrimination must show that their employer was the unusual employer and that it discriminates against members of majority demographics.
Katerina, I'm just going to add one more. I want to give a shout out to our partner, Barb Grangine, who is our office managing partner in our Denver office and a member of our labor and employment team, who, as we were speaking, sent me an email with a press release from the EEOC, which has filed a claim and made an announcement on a reverse discrimination claim that it's handling in Ohio against a restaurant chain. that allegedly discriminated against men in hiring decisions. The allegation, at least, is that the restaurant chain was expressing a explicit preference for women as servers and denying men those opportunities. So Katerina has given a couple examples, I think, that are focused on the race piece. I think that gender piece is also something to be aware of, and also consistent with what you're describing, Katerina, as, you know, what we're seeing in terms of an uptick, at least, of these claims being filed. So have we sufficiently scared our audience now? Can you tell us what this means?
Yes. So despite the recent challenges to DEI programs, employers can continue to increase diversity in their workforces and set aspirational goals with respect to DEI without running afoul of federal, state, and local anti-discrimination laws. However, we must be cautious when developing and communicating about and implementing DEI programs to make sure that you're not engaging in impermissible discrimination. Employers should immediately take inventory of their DEI communications, their initiatives, mission statements, et cetera, and audit them to confirm that they are operating within the current laws. We really see this as a good time to level set and review your current practices to make sure that you're doing things in a way that's going to mitigate risk as best as possible. And with that, I'm going to turn it over to Eric to ask our audience some more questions, but also discuss some practical tips for employers.
Thanks, Katerina. We're going to do a couple more poll questions before we get into, I think, some of the additional practical discussion. All right. Bear with me with my technology here. I am going to advance this slide. Does your organization have a formal diversity, equity, and inclusion policy or program? Again, we think this will be useful for benchmarking. As Katerina described, it's been really interesting for us to have observed this over the last several years as a number of our clients are beginning to sort of invest in this space. So please go ahead and select A, B, or C. Looks like a good critical mass. This is sort of probably a self-selection bias a little bit, because the sort of person who might attend a presentation like this is probably somebody who's been thinking about it. But it looks like nearly 80% of the attendees who are with us today have a DE&I program or policy. So I think that makes sense. I would say that that is consistent with sort of our experience of, you know, clients of a material size being interested in investing in this space. When was the last time your organization has reviewed its hiring policies and practices? So we've talked about, you know, wanting to make sure that we're remaining compliant, even if our perspective is the law isn't formally changed. Interested in when you've most recently reviewed that. So if you could please answer this one as well. And this will be our final poll question. Looks like we've got a proactive group here. Nearly 70% have reviewed those hiring policies and practices within the last year, about 20% within the last 5 years, and 10% unsure. I think that annual sort of cadence makes a lot of sense. There are a lot of things that you all have to sort of keep on your calendar and on your to-do list. So, you know, there's no federal requirement that this be conducted on any specific periodic basis. But because of the, you know, the way that things continue to evolve, doing that review on an annual basis, we think is a good best practice, at least. So Katerina's done a nice job of laying the groundwork for us in terms of, you know, how the law is evolving in this area, what we're seeing in terms of legal challenges, and what Amanda and I thought would be helpful would be to talk through, you know, again, in general terms, what we think are areas where employers can focus on modifying or ensuring that the policies that they have in place aren't going to attract unnecessary attention to make them targets of litigation or otherwise, and what remains permissible or impermissible under the law. I'll give a caveat. We use the word permissible and impermissible in these slides. That might be a little bit strong. There is a lot of gray area here. So to the extent that you read one of our hypotheticals and you say, that sounds like a policy that I have, and we've identified it as impermissible, I don't want you to freak out. I think that as Amanda and I will talk about, is that there is a lot of discussion and a lot of room in this space, but there are some things that we think are good to keep in mind. So let's start with a mentorship program. At least one of those cases that I think Katerina referenced, and one that I know that she and I had spoke about in a previous presentation, involved a large company that operated a specific mentorship program. And the intent of that mentorship program was to provide opportunities for historically underrepresented groups to advance in the organization. And in that case, there was language that limited the individuals who could participate in that program, so that it was limited only to women or historically underrepresented groups. Amanda, is that problematic? If we historically just use sort of that framing, and is there an alternative or better way for us to think about the sort of programs that we might offer to folks in our organizations that we want to support?
Yeah, absolutely. It is problematic. It's certainly risky to have any sort of exclusive program, as Katerina was saying. The more inclusive we can be with these types of opportunities, including mentorship programs, development programs, really the better. These programs provide a lot of benefits to those who take advantage of the program in making sure that we're retaining them, that we're developing this wonderful talent. And so we want to make sure that that's inclusive of everyone within the organization. However, there are some best practices that you can put in place, right? You can absolutely encourage women and historically underrepresented individuals with those identities to apply. The other thing that I always recommend is making sure that your mentors are receiving the type of training and support that they need to be good mentors for historically underrepresented groups. Make sure that there's some cultural competency understanding. Have them participate in implicit bias or other types of training that you're offering, so that as a mentor, they are ready to really help with the development and growth of anyone within the organization, but they are specifically knowledgeable about certain needs or barriers that may be experienced by people across the organization. Make them the best mentors they can be. And that includes racial competency, but also may include understanding what the historical barriers are for women or for veterans or for individuals with disabilities or for parents or other caregivers or at different ages. We have a multi-generational workforce now. Mentors should understand the different ways that generations are communicating. All of those inclusive behaviors within a mentorship program will make it a better mentorship program across the board.
That's great. That's very helpful. And you addressed one of the questions that I think might come up, which is, listen, if our intent is to develop this program to support people who may have not previously had opportunities at our organization, or a desire to bring diversity as we define that broadly, into the higher levels of the organization, can it still be effective if we're not using that specific or more targeted language? And it sounds like your perception and our experience is that it can.
Absolutely. Yes. 100%.
Great. Well, what's another sort of, I think when we think about processes inside of an organization to support historically underrepresented groups or individuals who are in non-majority identities, are employee resource groups. It's something that you and I have spoken a lot about, Amanda. I know something that you feel strongly about. Talk a bit about sort of the way in which an organization who's interested in doing that can structure those ERGs in a way that doesn't open them up to one of those claims that Katerina described.
Yeah, I'm happy to. Again, the theme of the day is going to be more inclusive and less exclusive, right? So with those ERGs, think about the membership of those ERGs being broader than simply individuals who identify with a particular identity. Make the space for the allies, for really anyone who is supportive of considering the barriers that may exist for that underrepresented identity, to be involved in the employee resource group. Now, employee resource groups serve a couple of great purposes. One of those purposes is to allow people with a particular identity to share their common experiences, celebrate their common cultures, talk about things in their lives that are important to them, and to be able to see that reflected in others within an employee resource group. But when you really have a best best in class employee resource group structure. The other thing that ERGs are doing are advancing the company forward in ways that remove barriers to equity, that create a more inclusive environment all around. So the employees should also be giving the employer some feedback and should be working in connection with the organization to advance those DEI goals. And in that way, allies and others across the organization that maybe don't identify with that particular identity, those voices are very valuable to an organization to help us understand how we create programming, recruiting, how we think about the other barriers to equity that are really advancing the organization, like benefits offerings, for example, how to restructure some of those things. So all of those policies and practices certainly need the voices of those underrepresented identities, but we really need the voices of all of those allies as well, advancing the company forward.
I have a hypothetical that I want to ask, but before I do that, I wondered, Katerina, I know that you have been active and previously in a leadership role with one of the employee resource groups, at least one of the employee resource groups here at Husch Blackwell. And I wonder if there's anything else that you would add to what Amanda described in terms of the value that you perceived as being a member of that group.
Sure. Yeah, I would say that the most significant value that I think comes out of employee resource groups is retention. Because you are creating a community where people know that they can communicate with others who come from similar backgrounds or similar cultures, which is something that your employees may not be comfortable doing with others. And so when they feel like they have an extra support system, they're more likely to stay and they're more likely to feel included. But as Amanda said, if you're going to have a successful employee resource group, you should have executive sponsors, you should have company buy-in, with the company understanding that these groups can be tasked with addressing certain business needs. And so they can be incredibly valuable for a number of reasons. I could go on and on and on, but I think those are probably the top for me in terms of benefit.
That's great. So the question I wanted to pose, Amanda, is, I sometimes will get calls from clients who are interested in setting up resource groups, for instance, and maybe what they have in mind is setting up a resource group for a particular race of individuals, a Black employees group, or a Latino employee group, or a LGBTQ group. And they will ask, well, what happens if, I have an employee who comes forward and says, well, why isn't there a group for white men? Even if the employee resource group is structured in the way that we're talking about here, which is sort of an inclusive attitude, do you have any advice that you give businesses that ask that question?
I do. So first of all, consider all of the requests that come in, right? If you're starting an employee resource group structure, then you're going to be receiving a lot of requests from, it might be a religious affiliation, it might be a generational employee resource group, it might be a parental employee resource group. And so before you advertise that we have employee resource groups at the organization, the first thing that you should do is understand how you're going to review those requests and those applications, right? So have that structure and system up front. Know who's going to review those and what criteria you're going to have for implementing those employee resource groups. Have it connected to your DEI strategy, your DEI strategic plan, right? What are the things that you as an organization are really focused on, and where do you see the needs of the organization forming? So that you can refer back to those policies, procedures, and structures of an employee resource group. And again, employee resource groups should be articulating not only the community, the inclusive community that they're building within the organization, but also the way that they are going to meet the needs of the employer and advancing some of these inclusion goals. Right? So I will typically say, if you receive a request that there is a men's employee resource group, you should ask that requester to put together an application the same as you would for any other employee resource group, and really ask that they articulate the need that that kind of gap that they're filling, and how they are going to help the organization actually create that more inclusive environment, or advance its DE&I goals by becoming an employee resource group. I think putting that back on the employees and asking them to be able to articulate how they're filling that need is a really important exercise. And then that committee can look at that application, again, connected to the criteria that it had set out, and determine if it's actually meeting that need. And what we find is that in going through that exercise, I've actually never had a colleague organization where the ERG sort of took it all the way through that exercise, frankly, and was really able to build a strong application for that particular group. But if they do, I think you've got to, again, use your criteria and make that consideration on a case-by-case basis.
That's really helpful. And I really appreciate the way, Amanda, that you're describing that process. I mean, again, it tells me that you're fluent in the language of employment lawyer. If you as a business are establishing a neutral process that you are following in each of those cases, you radically lower the likelihood that you're ultimately going to be held to have acted unfairly or discriminated against the group. Final sort of example to talk through here, and there was some allusion to this during those cases that Katarina was describing, let's talk a bit about, a goal that a company may set, right? There's a lot of news chatter over the last several years about businesses that have wanted to sort of enhance diversity within their workforce, however that's defined. Sometimes they're talking about gender, sometimes they're talking about race, sometimes they're defining it more broadly. But, in that Starbucks case, for instance, I think that Katarina talked about, there was a specific goal that company set that they wanted to meet. The question becomes, how do we think about those numerical goals, quotas, or even targets these days? Is as a business is thinking about that, is this still an appropriate thing to do when you're setting goals, to use percentages or numbers?
I think it's a very risky thing to do. I think it's always been a very risky thing to do, frankly, right? That's the employment attorney in me. Even as a chief diversity officer, I have never recommended that any of the organizations, that I work with or for, set hard targets and goals because of the risk of these reverse discrimination claims. And it's such a close connection to say, I as a white man wasn't hired for this position because my organization was trying to meet a particular target. And because they were trying to meet this particular target, they were presumably making these race or gender-based decisions at the time of hiring, and that they were so motivated by trying to make these targets. And in some of these cases, these targets are connected to bonuses for leaders, compensation structures for leaders, long-term incentive plan payouts for leaders, right? So if leaders are so highly motivated and held accountable to these specific targets, there's a presumption that they must be making hiring decisions based on race or gender or some other factor. So I have always encouraged a policy like you see there on the screen, where you are committed to aspirational goals of increasing diversity over time, right? Increasing this year over year. And seeing a progression, particularly where you have done some benchmark and you see some underrepresented, opportunities there. If you're trying to, if you're considering a material imbalance with regard to your own organization and the population of individuals that you're trying to recruit, and you want to see a progression over time of increasing diversity in that space. Articulating your goals in that way is much less risky. But I want to add, this isn't just about risk. I actually think the way that you set these goals has a downstream effect on the best practices that you're actually implementing. Okay, so as a chief diversity officer, and I hope all of you are really thinking about your actual hiring practices that are likely to increase the diversity of the candidate pool and therefore the diversity of those that you're actually hiring. It was never permissible to make a hiring decision based on race at the time of hire, right? And Eric, I hope I'm not getting ahead of myself here, but I think this is the right time to do it. We don't make that we don't use race as a decision-making factor when we're deciding who to hire. Let's say we have two great candidates. We're not sure who to hire, but we want to increase diversity, so we're going to hire the most diverse candidate of the two. We were never supposed to be doing that, right? So the best practices here to really think about diversity in hiring, you have to back all the way up to the beginning of that process. You should be thinking about, and this is harder work, by the way, but you should be thinking about how your job description is crafted. What barriers are you putting in place with the way that your job description is either crafted, the language you're using, the qualifications, minimum qualifications that you're setting. Where are you posting that job description? Who are you reaching with your job posting? And who are you attracting? What talent are you attracting to your organization? What sort of messages are you putting on your website, your web page, your LinkedIn profile? And who are they attracting to your organization? Who's interviewing? How are you filtering candidates or those applications that you're receiving? And is that creating some barrier to moving diverse candidates, however you're defining diversity, through the application process? Who's doing the interviewing? Do they have cultural competencies? Are they getting training on implicit bias? Are you creating any barriers with regard to who is on these interview panels, right? Are you thinking about the packages that you're putting together? Are you thinking about pay equity and flexibility and all of these things that are important to our candidates? Are you building a package that is more or less likely to increase the likelihood that diverse candidates will actually accept the offer that you're putting forward for them? All of those best practices in the hiring process will allow you to create more diverse candidate pools and will increase the likelihood that you will have more diversity in the people that you're hiring, because it's more likely that the best candidate for the job will be from an underrepresented identity. But you're still hiring the best person for the job. And that has always been the case, and that should always be the case going forward, both to mitigate legal risk and to create the best organization possible with the most phenomenal talent you could have attracted to your company.
That's great. There's a good reason that these presentations are recorded. I think I'm going to save that snippet that Amanda just shared as a nice roadmap and share it with clients, because I feel like it's super helpful. This slide is talking about, numbers and metrics. I guess the follow-up question would be, Amanda, is it still acceptable for us to track that diversity, to report it out internally to stakeholders, to leadership, all of that other stuff? Is that risky in your opinion?
I don't think it's risky. I think it's absolutely still permissible, and frankly, I think it's really important. Look, you have all kinds of risks, right? We all do, and certainly reverse discrimination risks are one of those risks. But we still have other types of discrimination risks and harassment risks and pay equity risks and all of those things that existed, that have existed for decades still exist. And you still want to be tracking demographics. You still want to be tracking and be knowledgeable about potential inequities so that you're able to remedy them within your organization. You should absolutely still be tracking all of this data to understand the demographics that you have, within your own company. And frankly, some of you on the line may still have obligations to do it, right? I know this isn't necessarily talking about affirmative action plans and federal contractors and OFCCP, right? That's not the subject of today. But some of you still have requirements that you're tracking some of those processes and data. And that didn't go away either.
That's helpful. I talked about the value of benchmarking. One thing that I can share with our attendees here, one of the things that our firm does in the data that it reports out to attorneys who are managing client matters or have client relationships is we have statistics that show us what percentage of the cases that we're handling are staffed with attorneys who belong or identify in underrepresented groups. we talk a lot about the firm about being able to sort of push back against some of the inherent biases that we deal with, and that, you know, we want to sort of think strategically and intentionally about. And so we're still continuing to utilize that. And I find that very helpful as I look at my dashboard on a regular basis.
And that actually brings up a really good point, Eric. We received a question from the audience related to tying these goals with some sort of incentive. And so we took, say, for example, we took our structure one step further and said, for those of you that excel in diversifying your legal teams, you will receive X additional bonus at the end of the year. Is that getting into riskier territory, or is that something that's okay to do?
Well, I don't know if Amanda has had that conversation with our executive board yet. I think my initial reaction is that it's probably getting into that riskier territory. I don't know that it is illegal or inappropriate, and I think there are organizations that have done exactly that. I think what she's probably going to say is that the more effective way would be to sort of say there are a pattern of behaviors that you are demonstrating when you are building a diverse team, which aligns with our strategic goals, and that's what we ultimately want to reward. What do you think, Amanda?
Yeah, absolutely. So I think it depends on how you do it, right? You can tell I'm a lawyer because I just say it depends, and then I but it really does depend on how you are building those compensation incentives, right? So if there's a compensation incentive, again, that's to a hard target, or saying you have to have a certain makeup of your team, or you have to do these very specific things that may run afoul of some of these laws and case law. That's not good. Don't do that, right? But I think if you are tying compensation to the ways that your leaders are advancing the strategic plan of the organization, right? And you're saying, hey, we have a DEI strategic plan. We want to increase diversity. We want to break down barriers in the advancement of equity. We want to create a more inclusive work environment. What are you doing to, you know, advance those goals and initiatives? And we can potentially score you on that, right? We can evaluate how you're doing. We can certainly determine if you're detracting from us achieving those goals. I think of DEI, I think of my role as a chief diversity officer the same as I think of other C-suite executive roles, right? So do your leaders have goals to advance the strategic plan in other areas of your business, right? To make your business more profitable, to increase the positive reputation of your organization, for example? I don't see it being any different with diversity, equity, and inclusion. We can require that our leaders are advancing that strategic plan, but we would never say, okay, leaders, you have to make our company more profitable, and it's okay if you do it in an illegal way, or it's okay if you do it unethically, or it's okay if you lie, cheat, and steal in order to make that happen, right? That's not what we're incentivizing. And it's the same thing over on the DEI side. Yes, we want you to advance the DEI strategic plan. We don't want you to do it by making a hiring decision based on race, but we still want you to do it. And here are some other ways that you can advance that strategic plan. And I think that's important, and that's still okay. Eric, if I'm wrong, you tell me before I go to our own executive board and before I say this again in front of clients.
No, that's exactly right. I think that is an effective and permissible and legal way to approach it. And I know it has a little bit of lawyerese in it, but I also think that there's some practical nuggets there that directly answer the question that Katerina shared. Great. Well, let's sort of finish up our slides here with some recommendations and conclusion. And I think there may be a couple of minutes left for us to address any other questions that the group has. You've talked on this already, Amanda, and we've touched on it in a couple of different contexts. You know, you're going to want to avoid using quotas or set-asides when setting hiring or advancement goals. There's a caveat here, of course, as Amanda described, if you are a federal contractor or otherwise subject to affirmative action rules. But generally speaking, many of those cases that Katerina identified are the ones where there are publicly communicated quotas or statistics and that's often, I think, what getting some of these businesses in trouble. Ensuring that you define diversity broadly. I've heard you speak about this before, Amanda, and you talked a bit about it at the beginning, but talk about, again, sort of how you want our clients and stakeholders to think about diversity.
Yeah. So first of all, I want you to define it, right? So you don't have to define it exactly the same as every other company across the board, but I do want you to go through the exercise of trying to define it. And I would encourage you to certainly think beyond race and gender. Think about other areas of identity that maybe you're under benchmarked in your own organization, right? Or you have a certain population within your organization that you want to make sure you're thinking about inclusive behaviors. So that should include LGBTQ identities and individuals with disabilities and veterans, and you can go broader than that and think about age and generation and caregivers and other experiences and identities. I also want you to think about intersectional identities and the way that those things are impacting people who have more than one of those identities or experiencing barriers in their own lives. And really think about your definition broadly. I would also encourage you, though, not to define it so broadly that you can't narrow in when you have a particular issue within your organization of someone, maybe an ERG, saying there's not an inclusive environment in this particular space. You want to be able to hone in. Sometimes I use the analogy of an accordion because my family is Mexican American and we love mariachi bands, and I love it when accordions show up in the band at a party. And so I often think of sometimes we need to be thinking accordion out, disability or diversity really broadly, including lots of different areas of identity. And when you're crafting your strategic plan and you're crafting your diversity definition and you're thinking about inclusive behaviors, do it broadly. However, you've got to be able to squeeze that accordion in. You've got to have accordion in moments where you see there's a particular need for a particular identity to feel more included or to have equal benefits, or there seems to be a glass ceiling at some part of your organization. You have to be willing to address that particular inequity and then move the accordion back out and make sure that you're doing things right for everyone. And if there's a particular identity that where it's just not working, you got to squeeze that accordion in again. That's the only way you actually get to kind of play the beautiful music right for everyone and make sure that everyone's actually enjoying their workplace.
Katarina and I are both musicians, and so Amanda's speaking our language when she's using the accordion analogy. We love it. I actually wanted to ask you, Katarina, you and I had an opportunity a couple months ago to work on a case for a client who was, let's say they were conflicted about implementing a DE&I program. But I thought that you had a really interesting approach there when you were thinking about how we defined the various different sort of pieces of that policy and really focusing on the I and the inclusion. Do you want to talk briefly about that?
Sure. Yeah. I think you're referring to a client that is in the healthcare industry. And essentially, the approach that we took and that in-house counsel was interested in hearing was, is there any legal risk associated with not implementing a diversity, equity, and inclusion policy? And, it was a great question because we usually don't get that. We get the opposite. What are the risks of me implementing a diversity, equity, and inclusion policy? And so we were able to pull data from the demographics where the hospital served its communities. And we were able to also find information through the EEOC of public settlements that had occurred on issues of discrimination in hospital systems, primarily the result of cultural incompetencies. And so basically our conclusion was that by not having some sort of sensitivity training, by not having these DEIA policies in place, you could actually be creating risk and losing certain patient populations because of insensitive comments maybe that staff had made. And so that was kind of a unique perspective, but then for their staff as well, in terms of inclusion, making sure that you are reflecting diverse communities all the way up, right? From your staff to your nurses to your physicians. I think people are going to be more inclined to stay if they feel that they have a path forward in your organization. And so we're also taking into consideration what's going to be the cost of the turnover that might happen if your workforce is or your workplace is not implementing these sorts of initiatives. And we've seen an increasing trend in, millennials, Gen Zers putting more emphasis on who they're choosing to be their employers based on whether or not they do have a formal DEI program in place. And so that, I think that's a huge consideration that we need to be aware of, and know that the culture might be shifting a little bit and people's priorities are changing.
This may be preaching to the choir a little bit with the audience that we have here today, because as we looked at our poll question earlier, I think we might have a self-selection for folks who are interested and engaged in this. But I think that info that you just shared there, Katerina, is part of our answer to clients who listen to a presentation like this and say, I'm nervous about the risks of continuing to invest in this space, which I know is important, but I'm getting pushback from my board or my executive level team or outside stakeholders about the way that we're doing this. It remains the case that there are all sorts of positive benefits, both to the bottom line, to employee recruiting and retention, and otherwise to these sort of initiatives. And so part of what we're hoping to do is support our clients who continue to invest in this space. So we've hit most of these other recommendations here, talking about removing barriers in the hiring process. Amanda mentioned that specifically, and I think that's a really effective way to think about when you want to enhance diversity. Mentorship and pipeline programs that are open to all employees. We talked about that during one of our hypotheticals. Providing anti-discrimination and anti-harassment training to ensure that you're in compliance with the law. Reviewing internal and external communications related to DE&I. Let's pause on that one for a moment. Again, I think the way that you are describing your initiatives, both internally and externally, is one of the key factors to avoiding becoming the next case that Katerina reports during our next presentation. Amanda, have you thought about that at all in the way, either here at our firm or otherwise, that you provide guidance to clients about how we communicate?
Yeah, again, be as inclusive as possible, right? Make sure that you're articulating a broad commitment to diversity and inclusion, but that you're also highlighting your programs in a way that makes it clear that while we're removing barriers for underrepresented identities, certainly because we're acknowledging them and we're taking proactive steps to remove them, that the specific programs themselves are open to individuals from all races and different identities.
Great. And then that last bullet, take all complaints of discrimination seriously, including reverse discrimination. In a couple of those more recent reverse discrimination cases that Katerina described, you will find some fact patterns where the allegation, at least, is that the employer blew off the employee when they came forward and said, hey, I think I'm being excluded. And I think that for some of us, there is a natural tendency to say, white men, for instance, in this organization have historically, enjoyed opportunities or are not an underrepresented group. So it seems sort of counterintuitive that that's a group that could be disadvantaged or that could bring a claim. I think the advice that we would have is that you try to remove that sort of reaction and instead treat that complaint the same way that you would treat the complaint of someone who does belong to a historically underrepresented class when they bring those concerns forward, and follow the process. That was the big takeaway from what Amanda described. If you follow your process, you're going to be in really good shape, and I think it's less likely that you'll find yourself in trouble. Some key takeaways here. As Katerina described up front, the ruling in the Students for Fair Admissions case does not immediately affect corporate DE&I programs. You saw that there's some chatter back and forth, but as we sit here today, that does not change the way that Amanda and Katerina and I are advising or assessing. Title VII has always prohibited employers from making employment decisions based on protected characteristics. That hasn't changed in light of that decision. And any DE&I initiatives in the workplace should continue to avoid making any employment or hiring decisions based on the applicant or employee's protected characteristics. Instead, that holistic approach that Amanda described, thinking about driving diversity through a more comprehensive strategy that includes the way you're thinking about hiring, those are the pieces of advice that we're giving to clients. I don't know, Katerina or Amanda, do you have any closing thoughts that you'd like to share with the group?
Yeah, I'd just like to say we've gotten so many excellent questions in our chat here, and we've been doing our best to respond to as many of those as we can, but we're surely not going to get to all of them in the next minute here. So if we did not get to your question, we will do our best to follow up with you after the program today. But I think it would be worthwhile, just as a closer, to ask both you, Eric, and you, Amanda, given all this recent pushback, is it still worth the risk to implement DEI policies and practices in the workplace?
Well, of course, I'm going to say yes, right? Yes, I think it is absolutely crucial. Like Eric said, the reasons why we do DEI work to create more inclusive environments, to increase retention, to make sure that we have diverse teams who we know, if we have diverse teams inclusively led, are better able to meet these client demands and do the best work possible. All of those things still exist. So yes, it's worth the risk. And as Katarina mentioned, there are still risks on the other side if you remove all of these wonderful DEI initiatives and back away from all of them, right? So you're not actually mitigating the risk by stopping your DEI programs. You're just losing the benefit of these wonderful programs. So absolutely keep them up and reach out to let us know how we can help you maintain them in the least risky and most effective way.
Yes, for all of the reasons that Amanda said. I've given a lot of thought over the last couple of years on what it takes to sort of build and keep a team, especially in an era where we're not always physically together. What makes somebody want to stay as a member of a team, as a member of an organization? And it seems to me, to channel a little bit of that Ted Lasso, it's about someone who feels like they are included, that they are part of something that's bigger than themselves. And these concepts of DEIA are a critical component to that. And so my anecdotal observation, and I think it's supported by the data, is that organizations that invest and continue to invest in this are seeing success in all those key economic and non-economic drivers. So I would say yes. Thank you all for joining us today. Thanks so much to Amanda and Katarina for joining in the conversation with me. We hope that this information was helpful to you. As I mentioned, this program is approved for legal education hours, and you can report those using the CEU icon on the bottom of your screen. You will get a certificate of attendance along with a link to the recording of the webcast that you should feel free to share with others in your organization. That email should be coming tomorrow. And finally, we'd appreciate it if you would complete that survey for us and suggest other topics that you think might be interesting. I have a feeling this is not the last conversation that Amanda and Katarina and I are going to have on this topic. This is an evolving area. We'll be monitoring it, and we're excited to continue to share our observations and thoughts with you. So this concludes our webinar. We hope you all have a wonderful rest of your day.